Before the introduction of no-fault divorce in Australia, a party who wished to obtain a divorce would be required to demonstrate to the court that they had proper grounds for seeking that divorce. Perhaps the most common ground was that of adultery. However, to make out the grounds of adultery, it was necessary to name the other party, and for them to be served with a notice making them a co-respondent to the divorce application. This was necessary to enable them to defend their own reputation from the allegation that they participated in adultery. For the other party to the adultery to be joined to the action, it was of course necessary that they be served with a notice of the divorce application, and that the allegation of adultery had been made against them. In this case, Mr. and Mrs. Graczyk were headed for divorce, and the grounds for the divorce were Mrs. Gracyk's claim that Mr. Graczyk had been adulterous with Ms. Avis Bell. Mr. Graczyk was not defending the divorce action, which suggests he too wanted the marriage to end, but as we will see, he was not really cooperative. A process server was engaged to serve the court documents on Avis Bell. The very brief notice of the case sets the facts out as follows. The process server knocked on the door of a bed-sitting room one night, and Mr. Graczyk opened the door, as a result of which the said Avis Bell could be seen seated on a bed in the lighted room. Graczyk prevented the process server and an identifying witness from entering the room and extinguished the light. The process server then called out in a loud voice, "I am being prevented from serving you with a notice required to be served on you personally. It is alleged that you have committed adultery with this man, and this notice is to give you warning of that fact. I intend to push the notice under the door for you." The process server then pushed the notice under the door. Justice Gavin Duffy was asked by the applicant wife to find that this constituted good personal service. He found that it was so. From this case, we learn that where a person refuses to accept service, placing the documents down and advising them what they are will constitute good personal service.